Okay, hello. We'll be starting shortly.
Where are you going? I'm not a part of it. It's fine.
Okay, so there's obviously some technical difficulties, but Alan and Adam are going to meet in here in a moment. And just forgive us for the setup, that you have to observe it.
Okay. Laura, is that working?
Yeah, you guys, that's working. I can hear you.
Okay, perfect.
So how do I get into, what do I do now?
No,
Nothing,
you're in,
Alright.
Alan. I can hear you.
Perfect. Okay.
Yeah, it's fine. Just gonna wait for Adam to take his seat. And Adam can spend, apologies for the late, but Adam can spend 5 minutes apologizing to everybody for being late because it was the CLA fault.
All right. Anyway, welcome back. Sorry we're 6 minutes late. We had some technical issues. Alan Gold is here once again to answer questions that have been submitted by our users. Just a couple things. One thing is, if you can pull up the link for session 4, it'll save me from clicking, going back and forth into the screen. So what I'm going to do is I'm just going to copy the link and paste it for everybody to open up their own SharePoint. And that way you can follow along with the questions with us. So for the first question for today is question 36. C. So it's from our third session. And the question is, I'm representing 3 siblings on a 278 application. In January, all three of these siblings agreed that they were content to go forward with me as their lawyer, as they all had the same interest. I received all the documents and reviewed them. I'm now prepared to review the documents with the three siblings. Since January, serious rifts have developed amongst the siblings. I wonder if it's wise to represent all three given the personal conflicts. The conflicts between the siblings are all personal. They have nothing to do with the issues before the court. The lawyer says they don't see any conflict regarding their fiduciary duty owed to each client and believes it will be fine to continue acting for all three siblings if they renew written instructions with each client. Alan, what do you think? And I commented on the question as well. Have the siblings received independent legal advice?
Yeah, and you're quite right, Adam. But this is a great question. I need to know more. Are the records the same for all three? Is there just one batch of records? Is there anything in the records that divides the three? What if you win for one and lose for the other two, or something like that? To me, this is a red flag. When people are in conflict for whatever reason, you really are asking for trouble representing them. You have no idea how in the real world things can change. What I would do, I would look on it as a great opportunity to refer two clients to friends who one day might return the favor, and explain to these people why you can't act for all of them. It's not going to be healthy. You're not getting along, and I don't want to be caught in the middle. I would not act for all three, even though it's quite possible you're right, you could do it. But to my mind, you're just really asking for trouble acting for all three.
Yeah, and in that scenario, though, if you were going to try to act for all three, wouldn't it make sense to get each of them independent legal advice?
Well, absolutely. I said that. You're absolutely right. They need independent legal advice. They need to be signed, sealed, and delivered very carefully. Otherwise, they're all going to start attacking you.
And I guess the point is, if you're referring people for ILA, why not just give them the file and make your life clean?
Exactly.
So 39C is the next question, also from our third session. What would be the best way to cross-examine a sexual assault complainant on the issue of waiting 3 months to file a complaint with the police? How would you incorporate this into your submissions to the trial judge?
The first thing to understand is you do not look like you're complaining about the delay. The delay is irrelevant, et cetera, et cetera. What you do is you want to examine carefully what this person was doing for the 3 months. Were they seeing a therapist? Were they discussing the matter with their friends? So the way I would do it is I would want to know what the person was doing for the 3 months. And then it may be that you can argue that something the person was doing is relevant to their credibility, but do not look like you're making anything of the fact that they took 3 months.
Okay, and the next question we have is 40C, which is from our third session as well. In an RVWD trial, the accused testifies, but during direct examination, she strays off script, fundamentally changes her story from what was relayed to counsel in preparation. In essence, the accused client witness attempts to minimize her involvement in the matter. As counsel, you know in your heart of hearts from previous trial experience that this testimony is possibly fatal to an acquittal. I think the lawyer's issue here is they don't quite believe what their clients said in the box. So what is the best course of action?
You have to understand you are in the midst of a great story to tell your children. What you do in this situation is you lean back and have a good time. You do your best to try to minimize it. But and this is where I emphasize you're just somebody playing a professional role. You shouldn't get upset. You shouldn't get mad at the client. Your job is to be the client's barrister. So you do not emphasize the changes. If the evidence is knowingly false, if it's directly contrary to what they've told you, that's one thing. But if they're just changing the story and it could possibly be true, and then you have to accept it. Now, you may not want to milk it. You may want to try and model it in your questions in a way to minimize what you think is the damage. But at the end of the day, think of this as a terrific opportunity to show how good you are. And one day you'll have a great story to tell your children. And that's all you can do. Clients are clients. Client, I think client comes from an old Roman word, clientus, meaning a person who has no idea what's best for them. I don't know.
Is to be answered is question 40C from our third session. In it,
that was 40C.
oh yeah, true. Next, try to cut and paste. It never works well. 34C, sorry.
Yeah, this is a really interesting question. Go ahead.
34C is quite long, so I'm not going to try to cut and paste it in for everybody. So if you just open the SharePoint document and go to it, it's at page 1 of the document, actually. I have a client who's charged with robbery, aggravated assault, and possession of a weapon. This arises from a situation where she attended at a home with 2 individuals with far more serious violent criminal records than hers, which is dated and totally devoid of violence. All minor credit card related property offenses are on her record. To retrieve a drug debt. She was invited to the home for this purpose. She's provided counsel with text to that effect. The client went into a room with the victim's girlfriend, presumably to consume drugs. During the period where she was not in the room, one of the other individuals at the house asked for the money, which the Crown suggests was owed to my client. The victim takes out his wallet to pay it, and the co-accused sees he has $1,200, and he demands all of the money instead of only the $300 that's owed. When the victim refuses to pay, the accused takes a machete, and in brackets here, there's no actual evidence it was brought to the home with my client and the co-accused. The victim admits to having machetes in his own home. So anyway, the accused takes out a machete, and the co-accused slashes the victim's face ear to ear. The Crown maintains that it's my client that is the drug dealer, and that it is my client who told the other individuals to take the money by any means necessary. But there's absolutely zero evidence in the disclosure that solidifies this theory in any meaningful way. My client's position is that she was owed cash. She attended with her boyfriend and other partner to get the money, as requested by the victim, and that she did not expect, know, or could not predict what the co-accused would do when she wasn't in the room. The Crown is relying on the evidence from the girlfriend that my client held her back once, this is the victim's girlfriend, held her back once they came running into the room and saw what had happened. My client says the girlfriend went and retrieved a machete at this point and told them to leave the home under threat of violence. And the girlfriend says that my client held her back and kept her from interfering. I just don't see how this makes out the charges that my client is under, much less a case that will be successful at the further ground at trial. But I am concerned that I'm missing something, as the Crowns I respect seem convinced this is a slam dunk. Do you have any advice for a relatively young call in terms of taking this to trial, how to approach the Crown in regards to resolving a matter on which they've taken a position I feel is untenable? It is currently screened for 10 years. My client's pregnant, has never served more than a 15-day sentence.
Well, this is an interesting case. I think it's a great case for a young lawyer. And the first point is to get your issues straight. As I understand the fact situation, and by the way, the fact that Crowns think it's a slam dunk is meaningless. They all often think it's a slam dunk when it's not. As I understand it, what the Crown is saying is that the fact that your client held back the girlfriend is evidence that she was part of a plan in advance to rob and, if necessary, injure the victim. That seems to me to be what the Crown is in effect saying. On the face of it, of course, it's weak and it's not consistent. Holding her back has other explanations besides being consistent with, I knew what was going to happen and this is my contribution to the endeavor. So in terms of how you handle it, first of all, you say that your client was not the drug dealer. So you need to know what evidence is there that one of the people in the room, not your client, was in fact the drug dealer and that it was their debt. is there evidence of previous pickups from this location that went without any difficulty? Also, what's important is, what did you know about the co-accused who launched the attack? Did you know that this person had a bad record for gratuitous violence, stuff like that? In other words, to what extent can your client claim, I did not know that this guy would decide to take all the money and go berserk on his own, that kind of thing. So those are how I would break down the issues. I think they're good issues. You can contribute a lot to them, do a lot of work, but ultimately the question is, does your client holding back the girlfriend, is that sufficient proof beyond a reasonable doubt that the only reason she did that was because she was part of a pre-plan to rob this guy? It would be helpful if your client attended at previous times to pick up a few $100s and there were no problems. That without this particular co-accused who caused the problem on this occasion. So that's what you're always doing. You're always looking for comparison evidence to show that your client did things that are inconsistent with her planning to do something on this occasion. I don't understand the question about resolving it, because I'm not sure what you can resolve it for on the basis of the facts if you stated. The only other offense I see is an assault on the girlfriend by holding her back, and I doubt that the Crown is going to accept a plea to that. So I'm really not sure how you can resolve it. Your client seems either innocent or she was a party to this plan to rob the guy and, if necessary, use violence.
We have is from session 4. It's question 1. So starts off with, thank you for sharing the Gravel case about the bogus lip reader. For those of you that were with us last week, it's in the More Tough Crimes book. What a coincidence, your friend had just finished a trial with the same expert. Assuming you hired a private investigator to create a scenario of a couple surreptitiously meeting at a park and being secretly videotaped, how would you admit the evidence at trial? Would you ask the private investigator the hypothetical to read the couple's interactions and then call the PI and introduce the actual audio recordings? It's very interesting, Mr. Gold. And then part B is, how do you know the British barrister Edward Hunnery?
Yeah, I view that as an insurance policy. If this lip reader ever pulled a mysterious resurrection and appeared again, and it wasn't that expensive. How would I prove it? Well, be in cross-examination of her. I would have her report, and then I would be able to produce the tape, and I would produce the recording of what was actually said through the private investigator. It wouldn't be difficult. I probably would not have to call my friend lawyer in Los Angeles who retained her for this imaginary divorce case, et cetera, et cetera. There would be no problem introducing her, but it would only be in cross-examination of her if she appeared as a witness. If she didn't appear as a witness, it was just a form of insurance in case she ever pulled a magical resurrection. How did I know the British barrister? He had emailed me. I don't really remember, but I think he had emailed me asking about Canadian law regarding release of funds, because he was bringing a funding application in England, and I had written one of the most unsuccessful law books ever written on proceeds of crime, because they changed the law immediately after the book was published. So. But in any event, I would have found out what happened, because I would have if necessary, phoned up lawyers in England. I would have found this information no matter what. But it was just a coincidence. He said to me, I can't believe you're asking about her. We just finished a case with her and we destroyed her. Remember, Napoleon once said, send me lucky generals. You know, sometimes it's better to be lucky than good, although if you're both, then that's great. But yeah, luck is an important part of what we do.
Okay, the next question is question number 2 for this session. In Olin's first trial, when you received the guilty verdict, did you poll the jury? For those of you who don't know, did you have the jurors individually confirm they voted for this verdict? If not, why not? And also, why would counsel poll the jury, and when would it be appropriate?
Yeah, this is this is something that used to be common, because the theory was if one of the jurors said not guilty, then it was a mistrial. To me, it's always been very depressing to listen to all 12 of them say not guilty. And if you have a multi-count indictment, you can be listening to guilty, guilty, guilty 48 times, which is really, really depressing. So I'm not a big fan of polling the jury, especially since in modern times, a judge would not immediately declare a mistrial. He'd probably re-instruct the jury and send them back to reconsider. In other words, I don't think modern judges would let it go the way the way judges used to do it in previous times. So I'm not a fan of polling the jury. I find it too depressing to hear them say guilty so many times.
All right. Question number 3. What is the best way to deal with a client who's detained on very serious charges, for example, firearms, drug trafficking, who insists on having a bail hearing as soon as possible, even though there's not a solid plan put together for bail? Or potentially it could require the lawyer some time to put one together. In other words, how should a lawyer deal with the pressure from the client to act quickly when the lawyer wants some time to come up with a reasonable solution to actually help get the client out of custody?
You explain to the client that no means no. As well, you can explain to the client that when you go and lose, their only recourse is going to be review, which is even harder to win. No, it's at some point you just have to put your foot down and say, no, that you have no chance. I will look ridiculous, which I'm not prepared to do. And if you want to find a lawyer who's ridiculous enough to bring a bail application for you, then the phone book is filled with other lawyers. I suspect you probably will not find a lawyer who will agree to do this because it's an absolute waste of time. But I'm not going to do it. You just have to put your foot down.
And question number 4, this is about the Olin documentary. So the first question is, aren't jurors sworn to secrecy? How is it okay for the juror to be interviewed for the Olin second trial on the CBC documentary? Was this due to the jury being discharged in a proceeding by judge alone, that the juries were no longer prohibited from disclosing information?
First of all, there were no deliberations. The jury was discharged. And the code provision is about disclosing deliberations. Now, I've always interpreted that a juror can always discuss their personal thoughts and impressions. So there's nothing to prevent a juror coming up to you and saying, I think you were the best lawyer I've ever seen, or you're the worst lawyer I've ever seen. I don't know why this person hired you. But in fairness, the Manitoba Court of Appeal a couple years ago interpreted that provision broadly and kind of put the kibosh on that. But in any event, in Olin, the juror that agreed to talk had been discharged. There were no deliberations. The juror was just discussing their personal experiences. Much of what she said was a matter of public record, so there really was no concern about that.
Okay. And the next question we have is question 5. Any tips on surrendering control? Sorry. I didn't write this question, I swear. Any tips on surrendering control and trusting students or junior associates? I often get disappointed when students or junior lawyers who I contract work out to miss details in a notice of application, copy templates, but miss changing important details. I know this is a skill that needs to be honed and learned. How can I be encouraging to them when I am, in fact, actually disappointed? Sometimes I think I'd rather just do everything myself, because reviewing and redoing tasks is also challenging and time consuming. How do you transition from working alone to having a firm? How do you encourage students when they are not very knowledgeable, don't ask many questions, and are careless with their work? I mean, I think they just have to hire someone like I have, Michelle or Laura, but anyway.
First of all, I've never wanted to build a firm because I'm just not a firm type of person. The question you ask is one that every lawyer who's been out a couple of decades faces. First thing you have to understand is that during articling, your job is to help the student overcome everything they've been taught in law school. And if necessary, hopefully forget it all, because in the practice of law, so much depends on detail, so much depends on drudgery, mundane tasks, just being careful, just doing boring stuff very, very well. And that's difficult. You always have to be professional with people, but don't hesitate to say, there's this wonderful little book published by the American Bar Association called The Curmudgeon Lawyer, which I give to everybody in my office to read when they start. And it contains chapters like, don't give me documents with typos. I'm not your proofreader. You're supposed to catch all your own. And people that work with me will tell you that when I see a typo, I view it as an insult. Like, you don't care enough to give me stuff without typos. So all I can tell you is you try and do the best job yourself, and try and find people, and people will improve over time. Be patient. Don't expect everybody to be perfect the day they walk into your office. You weren't perfect. I wasn't perfect the day I first walked into a law office. What you're looking for is what I call teachability. You want people that you can teach and who will learn over time to do things right. And as I say, the main problem in doing things right is that so much of what we have to do is drudgery. It's making sure the documents are absolutely perfect without typos. But you do all of this drudgery, mechanical work, so that you can stand up in court and be brilliant and have an exciting day, have an exciting cross-examination. But the things that are fun and glamorous are really the tip of a gigantic iceberg, which underneath the water has all of this absolutely dull, drudgery, mechanical work that you have to do. That's all I can tell you. And be patient with people. Everybody is on a bell curve. Okay, the average is called an average because most people are average. There are a few people that are on the far right. There are a few people that are on the far left. But most people you're going to meet are average, and you just try and work with them and try and get them to have a philosophy to be the best they can be. And that's really all you can do in your professional life.
Okay, this question number 6 we have. I've always been curious why in some judgments, judges address some issues but decline to address others. They have an opportunity to rule on a matter, maybe make good law, but they refuse. For example, I had a refusal case. The judge agreed there was reasonable doubt that my client refused. My client was actually acquitted, but there was also a 10B issue, and the judge simply wrote that it was not necessary for her to address it. I've never had the courage to ask this of a judge. What's your judge friends say? Any insight? My father always told me to keep your mouth shut when you're winning, but I don't know.
What did I say about a bell curve? Okay, judges are on the bell curve. Sometimes judges are really interested in an issue. Sometimes they're not going to do the extra work if they don't have to. That's just human nature. And every lawyer has been in this situation. I've filed brilliant factums expecting a brilliant decision, and you get a perfunctory endorsement. Who knows? The judge may be having a bad day. The judge's interest may lie somewhere else. It's simply part of the human judicial experience. And some judges, you may or may not know, some work harder than others. Some judges write very few judgments. Some judges write lots of judgments. Some judges want to leave their place in history. Some judges don't care. They're just working towards retirement. All of human activities on a bell curve, including judges.
All right. Question number 7. I thought it was very helpful when you told me to use "can you confirm" instead of "do you agree." I think this was in the context of last week when you were trying to get the Crown to confirm omitted pieces of evidence from the complainant's, say, preliminary hearing transcript or witness statement. So can you confirm instead of "do you agree," since the mind is more inclined to the former being "can you confirm" rather than "do you agree." Any other useful examples for this type of psychological trickery that will work in our favor?
No, you have to understand, language words are your ammunition, your tools. How you say something should depend on what you are trying to achieve. So ask pollsters this. The question a pollster asks will determine the answer. You can ask the same thing two different ways and you'll get exactly opposite results. So people are always in favor of supporting something. They are always against banning something. So typical language that I use, for example, is to try and use the word courtesy. Please do me the courtesy. Why? Because the Law Society says we're all supposed to be courteous to each other. So if you're asking for a courtesy, right away you've kind of got an emotional little jab there. If the person says no, oh my God, you won't do me a courtesy? Lawyers are supposed to do courtesy. I always talk about I appreciate your efforts. I apologize for the imposition. That kind of language where you're trying to show the other person that you understand their side of it, but this is what you'd like them to do. So yes, language is a lawyer's ammunition, and it's really important that you develop a sensible vocabulary and a sensible way of presenting your thoughts and your wishes, and increase the odds of them being complied with.
All right, could you do the courtesy of answering question 8? I had a jury trial some time ago, and I had a very difficult witness. I could sense that I was losing confidence from the jury because the witness was not giving me much to work with. I could just picture the sweat beating on my forehead here. He kept answering no. I find that the witness who elaborate on their answers often give me much more to work with. This was a male witness. He was always short with his answers. When I put something to him or confront him on an allegation, it was a self-defense case, he would simply deny it. I went through a host of confrontations. He kept just saying no. I eventually switched gears because I was getting nowhere. My client was actually eventually acquitted, so clearly this lawyer did everything perfectly. But do you have any general tips on what to do with a difficult witness such as this one that just basically won't say anything other than no? We hear that in the Olin case, there was a very combative witness who refused to acknowledge when he first heard the thump noises. How did you deal with that witness? And what is your strategy when a witness refuses to give you the answers that you're seeking that seem obvious?
First of all, you won the case, so you must have done something right. I'm not sure why a witness who gives short answers is bad. That's much better than the witness who gives long answers, which could include damaging material. So a witness who's prepared to give short answers, it's up to you to then break down where you want to go and to use the short answers to take you there in baby steps. Other than that, I'm not quite sure what I can do. I mean, in Olin, this was a witness who was biased because we had evidence of it from his postings and that, who came to court expecting me to lambaste him and to accuse him of all kinds of things. And instead, I was just very soft-spoken, asked very simple questions. There's no ambiguity, no words that you could debate. And he was ready to explode, and he did explode. So he looked ridiculous. He was overreacting to very simple, harmless questions. And so that was very effective. All I can tell you is the following. Some of you may know Thomas Kuhn. He was an American physicist and historian and a philosopher of science. And his most famous quotation that he's known for is, "The answers you get depend upon the questions you ask." And pollsters know that, and that's absolutely true. I like that, but I kind of turned it around. I said, the questions you should ask depends on the answers you want. So even if someone's giving you short questions, what is it you want this person to say? And that is how you formulate a question. Always ask yourself, what words do I want to come out of this person's mouth? And then you formulate the question that must inevitably produce those words.
All right. So the next question is question 9. Yeah, this is a nightmare, but you can get through it, I'm sure. So I had a child sex assault case. I prepped my client. He told me one story during preparation, and then in examination in chief, he changed his testimony. I could not believe him. When I asked him if he kissed her on the face, he answered, "I may have." When I asked him if he kissed her on the forehead, he answered, "I may have." This is not how he answered when we were in preparation. Now, before the court, he started seeming very evasive. And then before the judgment, for the first time, I presume this is after he's already testified, he tells me that once he had inadvertently placed his hand near the complainant's vagina. This is his 9-year-old niece. And she said to him, "Oh, I like it." I believe this also was a complete lie. Have you ever encountered clients who just change their story on the stand? How do you deal with this? What's the best way, if any, to rehabilitate them? When clients perform poorly, I also worry that judges get the impression I didn't do my job of preparation adequately. Do judges understand that sometimes, despite all your efforts, clients are just liars or idiots?
Yeah, don't worry what the client is going to think. Judges know, but don't show surprise. Don't react. Don't throw down your papers, okay? First of all, in the example you give where the client says, "I may have," look at the glass half full. You go to the judge and say, "Judge, my client is such an honest witness. He admitted things that made him look bad, but he was telling the truth. He admitted he might have." Unless you know the evidence is false, in which case you don't go anywhere near it, you don't mention it, you don't rely on it in any way, shape, or form. But I presume from the question, you just think that he's being more honest in his evidence than he was with you. At least if you can take that position, that's the mindset you should have. Oh, now he's being more honest and he's hurting himself. Great, argue to the judge. Any answer that a client gives that hurts him can always be characterized as a badge of honesty. This man is honest, otherwise he would not be admitting these bad things. So there's always a glass half full approach. Other than that, my advice is enjoy the roller coaster ride. Again, it's a great story. You know, it's part of the professional fun to have these challenges and see how well you do with them. Stop thinking you're your client's savior. You're not your client's savior. You have a professional role to play. And if the client makes life exciting for you, view it as an exciting professional experience from which you will learn and grow and become a better lawyer. So don't get upset about stuff like this, and don't worry about the judge thinking badly of you. Judges will quite understand. If you want the judge to know for sure this is a surprise for some reason, just pause and count to 5. And the judge will know you weren't expecting this answer and will know it's not on you. If you want to do that for your own sake, that's fine.
All right. Question number 10. When a complainant is an excellent actress and she cries on the stand to get sympathy from the judge, what is the best way to deal with this? What do I say? Do I ask the witness if she needs a break? What do you think the best way to handle the crying, overly dramatic complainant witness is?
Well, first of all, I can't assume she's just an excellent actress. I'm going to answer the question on the basis you have a crying complainant. The problem is you may think she's just being an excellent actress. The judge may think she's being sincere and credible. So always best to give the complainant the doubt and just be neutrally professional. The judge will appreciate it no matter what the judge thinks of a witness. Do not assume the complainant is making a face or by throwing your papers down or anything like that. You don't know the judge's perception. So be professionally neutral, and you do not address the complainant if she needs a break. What you do is you look at the judge, and the judge may say, perhaps we'll take a break, or you say to the judge, Your Honor, does Your Honor think we should take a break at this point? So always speak to the judge, not the complainant.
And question number 11. This person has a client charged with gun offenses. He was strip searched and arrested in the summer. During the arrest, he was only wearing shorts and a t-shirt. There were pat downs and nothing was found. No guns, no weapons, no sharp objects. He was compliant and had no history of self-harm and was cooperative throughout his arrest. At the preliminary hearing, I challenged the officers that there was no reason to believe he had anything on him. The officers gave the typical answer that a level 3 search was authorized because of the nature of the offense being guns, and that the client had a history of violence. He had prior robbery convictions. Another officer mentioned, which I've been waiting for this question because I just wanted to say this line. Another officer mentioned that once an unrelated accused person had a gun taped to his balls. So you never know when you will find or what you will find in a level 3. Officers will never agree that they are doing this as a matter of routine, but clearly there needs to be reasonable basis to strip search beyond the nature of the offense and the fact that he has prior convictions. How would you have handled this cross-examination, Mr. Gold, to the officer with the creative responses?
Well, first of all, I'm not sure I see a problem because your hypothetical shows the police evidence did not justify the search. I thought we agreed that the law was there had to be a reasonable basis for the strip search in the facts of the case, beyond the nature of the offense and the fact of prior convictions. So your first argument is let these police go off on the wrong basis. If their position is we only did it because of the nature of the offense and because of the prior convictions, as I understand the law, you have a good legal argument right there that they're wrong. But assuming that's not correct, emphasize that what was done in other cases was based on those other cases, generalized and inappropriate and irrelevant experience. For example, the gentleman with the gun taped to his balls, I presume, was not wearing shorts and a t-shirt. I presume he was probably wearing pants somewhere around his ankles. Otherwise, I only have personal experience with that part of the body, but how big a gun was it? I mean, he must have been wearing very loose-fitting clothing. So that kind of thing. Your guy is in a shorts and a t-shirt. So what you do is you show that the police references to other cases all have distinguishable characteristics that made those cases as precedents inapplicable to your case. And so in the ball gun case, was that accused in shorts and a t-shirt? Did your client's robberies involve guns? Did the police even check if your client's robberies involve guns? So you're always looking to emphasize the facts of your particular search case compared to what the police considered as relevant information and distinguish it.
Okay, question number 12.
Especially, for example, was your client's gun, well, your client didn't have a gun, but were your client's balls capable of hiding any kind of a weapon?
It's not if you're calling it the ball gun case. I got to ask another question. Stop. All right, so question number 12. In oral advocacy, some of us young lawyers are married to a script. I feel more confident to have everything written out. How do we transition from a script to just point form notes while giving a great oral advocacy performance? I've watched your performances in the SEC archives. I tried to edit out all the really complimentary stuff because I don't want it to go to your head, but I couldn't do it with this question. You're not reading. You make it look easy. Do you memorize your submissions? Are you forming the sentences in the heat of the moment? Or is it just a matter of practice and going over the materials over and over again?
Okay. In school, do they still have open book exams versus closed book exams? That's the comparison. Reading from a script is like an open book exam. What I do is a closed book exam. I learn the case like I would learn a part of a course, not like you learn lines in a script. It's more like improv than stand-up comedy with a collection of jokes. You learn the file so well that you can discuss it with your friends, you can answer all their questions, all their objections. You learn it, and then you go have a discussion with the judges. You that's how I do submissions. I don't know how else to tell you that. No, if you write it out with a script, you don't know enough for the things you haven't anticipated, because no script can be complete and cover every eventuality. When the judge asks you a question and you know that file, you can answer it, and that really enhances the quality of your submissions.
Okay, question number 13. Do you still begin your submissions with, "May I please the court? I see some counsel do this and others don't. Is it antiquated? What is the history of this phrase, and why do some counsel begin their submissions in this way?" And I'm pasting in an article link you asked me to do here for the chat for everybody.
Yeah, I thought this was a great question. So I looked into the history of the phrase. And there's a link there for an article in the American Bar Association Journal all about the phrase. It is a traditional phrase. I do like it. I'm a traditionalist. I like to have a beginning and an end. And "May it please the court" is the most common opener in the 19th century. There were variations. Some lawyers said, "May it please your honors." One of the leading American lawyers who served as a Supreme Court justice habitually opened with, "If the court please." It's simply a historically acceptable. And the article makes the point, what else are you going to say? You're going to say, "Hi, good morning, what's shaking, chiefy baby." It's a way of starting that everyone uses, so you're all starting. It's like the starting gun or the starting bell at the horse track or a race. It's a starting gun. Everybody now knows you started. Everybody starts the same. There's no ambiguity as to when they should start listening to you. And I like that opening. I guess younger lawyers, more casual lawyers don't do it, but I always do it. I do it even in any of the courts that I'm in.
Okay. Do you have any other favorite ways to open other than "May it please the court" that you think are appropriate?
Yeah, I don't think "Yo Judge" is a good way to open.
All right. Question number 14. This one's a little bit of a long one here, so everyone be patient. I'm in a situation where my client pled guilty to human trafficking charges in the Ontario Court of Justice. They acknowledged the facts read in as true. Afterwards, that same client applied to have his plea withdrawn. And as part of that withdrawal application, the client was cross-examined on the facts that he pled to, and he did agree, he admitted them. The basis for withdrawing the plea of guilt was due to an immigration consequence issue, not the factual facts that he admitted. In fact, there was going to be a Gardner hearing scheduled. So the plea was successfully withdrawn on the basis of the harm to the accused immigration status. So in bringing the bail review, the Crown made attempts to lead evidence of the plea and its withdrawal being due to immigration, not that the facts were disagreed with. The Crown logic is that he did do it, and it's admissible at a bail despite it not being admissible at his trial. The counsel strongly opposed. However, in this situation, they felt as though the damage was done once the judge knows it happened. The counsel says, "I understand that we're supposed to assume judges can disabuse their minds, but I think something like this is just too prejudicial for the judge to even see. It serves no purpose but to suggest my client's guilty. It doesn't make it any better that the complainant died before his plea was withdrawn, weakening the Crown's case dramatically. Is there anything I can do to wash or at least minimize the stink of the withdrawn plea?" The judge I had at his last bail review stated, "Well, he did it, didn't he?" And then he didn't rule on the admissibility of the guilty plea at the bail review, but just detained him for some other reason.
This is a toughie, but two thoughts occur to me. First of all, you have an admission of all the facts, but a guilty plea is also a waiver of any possible defenses. Is there any possible defense that you're now going to raise at a trial? I presume you're going to have a trial because you can't plead because of the sentence or whatever. So one way to do it is to say that, well, the guilty plea, we agreed to the facts, but there's this defense that we're now going to raise because we're now going to go to trial. So you want to show the judge that a conviction is not a foregone conclusion. Other than that, the only other thing is how long is the contemplated custody? If there are immigration consequences, does that mean you're going to try and get a sentence of 6 months less a day? Would the Crown agree to that? If so, then how much time has he spent in detention? Because you know the rule, you're not going to have to stay in detention longer than any sentence you're going to get on a conviction or a plea. So those are the only two things I can think of. But other than that, I'm sorry. Yeah, his not just the plea of guilty that was struck, but his admission of all the facts constituting the offense. There's no way to prevent it coming back from haunting him and you, unless there are defenses that you can now say, well, this is the admissions aren't the whole story. There are these defenses we're now going to raise because he's not going to plead guilty. That's the only thing I can think of to undermine the prejudicial effect of what happened.
Okay. Question number 15. This lawyer had a jury trial where in her closing, she suggested that her client's statement was unreliable. It was not reliable because it was clear that the client wanted to impress the officer, and two, that the client made several exaggerations in his inculpatory evidence that cannot be true when assessed with the evidence of several of the eyewitnesses. The lawyer did not have a basis for actually challenging the voluntariness or admissibility of the statement. So after her closing, the Crown stated that it was implicit in her submissions that the client's statement was not voluntary. The lawyer stated there is no issue with voluntariness, but there's a difference between reliable and unreliable evidence. The judge in the end, in the instructions, told the jury to ignore any suggestions that the statement wasn't voluntary. Again, this is something the lawyer never suggested. She just suggested it was unreliable. How would you have handled this situation?
Well, I think you're absolutely right, and the Crown and the judge are wrong. They seem to be confusing the rationale for the voluntariness rule with the rule about involuntary statements being excluded because they may be unreliable. But unreliability can arise from conditions other than involuntariness. And in your case, for example, the desire to impress or even simple error. Of course, one of the most obvious things you do is prove that your client's statement to the police is inconsistent with objective evidence. So all I could say is you're right. You keep taking the position. I don't know why the judge would instruct the jury about it not being voluntary. Based on what you say, there was no reason to mention voluntariness at all. And it sounds like you have a good appeal.
So this is something the lawyer probably should have objected to in the pre-charge conference on that basis if they knew that was going to be in the charge.
Absolutely. Unreliability is a broader concept than involuntariness.
Okay. Question 16. There's an aggravated assault case, a bar fight, and the lawyer wants to challenge the warrant permitting the search of his client's phone. The information to obtain relies on surveillance stills 14 hours before the fight of someone the police say is his client using a cell phone. Video and photo is not clear regarding the make model of the phone, and the lawyer doesn't believe this is his client. The surveillance was at a motel. There's other surveillance of his client at the motel 4 hours prior to the fight, where his client is not wearing the same thing as the male in the surveillance photo with the phone. He acknowledges that that is, in fact, his client. There's a search incident to arrest 6 months later. A Samsung phone was found on his client. In his video statement, he told the officer he'd had this Samsung phone for 1 to 2 years. This time period covers the incident. The lawyer looked at the surveillance, and it's not clear in his opinion that the male using the phone is his client. The male using the phone was wearing a purple hoodie and red pants. His client doesn't even own any of these items. There's no independent witness or leading witness that can identify his client. There is some evidence connecting his client to the bar fight, but there's no evidence that his client was using a cell phone or had a cell phone with him at the time of the offense. In his opinion, there's not enough connecting his client's phone to the fight that would warrant the search. So again, I think the question boils down to the two things I kind of highlighted and underlined. How should the lawyer approach it? Should they request leave to cross-examine on the affidavit, pull up the surveillance, and request the affiant, and challenge the affiant that he cannot possibly conclude the male in question with the phone is his client, since the video isn't of sufficient quality and clarity? Or should the lawyer simply argue the Section 8 on the face of the warrant that the evidence cannot be reasonably support the belief, and that there's no reasonable basis to get into the cell phone?
Yeah, the crucial evidentiary link is, does the ITO disclose reasonable grounds to believe that the surveillance video with the client at 4 hours before is sufficiently similar to the surveillance video of the unknown person 14 hours before for a reasonably based probability they're the same person? And so questions arise. First of all, I take it the clothes are different, but that may not help because there's a 10-hour difference between the two photos, which is a different time of day, but it would be helpful if it was the same type of clothing. In other words, that the accused didn't go from daytime wear to nighttime wear or something like that. It's the same type of clothing, the difference in clothing. So yes, I would request leave for the officer to cross-examine the officer on what basis they suggest it's the same person. It's different clothing. The 14-hour surveillance still has certain clothing which you say your client doesn't own. Did the police ever look for those clothes, for example, after arrest, to show that they didn't recognize the significance of those clothing? So yeah, I would cross-examine on disparities between the two photographs, that no reason, and what the police did to recognize those disparities, to point out to the justice that it may not be the same person. Otherwise, yes, that's your argument, that there was no basis, reasonable belief that the person in the 4-hour photograph, which was your client, is the same as the person in the 14-hour photograph. So you're looking for all differences between them, and information that the police left out, for example. What other information did they have about the surveillance, the 14-hour surveillance photograph? Did they inquire as to that person, if he was known at the hotel? Did they check out or something like that? You're looking for anything that the police should have done to investigate the issue of whether it is the same person, because that had to be presented to the justice, because the police were asking the justice to believe it was the same person. That's the crucial factual issue.
All right, question number 17. There's a sexual assault trial in progress. The Crown has rested their case. The defense has its last witness, the defendant, on the stand. Direct examination of the defendant is complete. The Crown is in the middle of cross-examination, and now the trial is on hold due to COVID-19 and scheduling issues. Despite the recommendation of counsel to the contrary, the defendant had underwent a paternity test, which came back indicating that the defendant is the father. Presumably, this is of the child of the sex assault victim. The Crown wishes to introduce the results of this test while he is cross-examining the defendant. What do you recommend the defense do in order to prevent the introduction of this test result? By way of background, the complainant claims to have been impregnated by the defendant from a single encounter, which was not consensual. The defense has shown a long-term relationship between the parties, which had been consensual at all times.
I'm not understanding how paternity is relevant or even prejudicial. To me, the reality seems neutral. It's paternity of Adam. You say it's paternity.
She's claiming she got pregnant from the one sexual assault encounter, and this lawyer's showed a history of them being in a relationship.
Yeah, I don't understand why paternity is prejudicial, because in fact, paternity, the fact that she got pregnant, if you're old-fashioned, you might even think that's more consistent with a relationship versus a single occasion of sexual intercourse. And if nothing else, your judge may think that at the back of their mind. I mean, my problem with this question is I'm not understanding why defense counsel is concerned about the paternity evidence.
Yeah, because I mean, I think a lot of people would know it would be somewhat less likely that someone would get pregnant on one instance, even if you can't say it's impossible, but it's not necessarily easy to get pregnant, as a lot of people know.
It's probably an impermissible example of stereotypical reasoning, but it's simply a numbers game. I would think that he got her pregnant. He gets up there and claims to have a long-term relationship. She says, I only had sex once, and he's proved to be the father of a child. I would think psychologically that would tend to support his evidence of a long-term relationship.
Well, not really a permissible thing to make submissions on. It's going to be in the back of everyone's mind probably. So question number 18, congratulations on your win in the Terrio case. Why did you choose to go judge alone? It worked out in the end for your client. I'm curious of the rationale.
Just because the defense was quite legalistic, and the optics, as you know from the nature of the case, the optics were quite controversial. There was just a lot of potential for. Jury selection would have been difficult, quite frankly, and my personal rule is, as long as the judge I'm given is as good as a jury, if not better, then why not shorten things up and take the judge? And it just seemed that kind of a case for a judge.
The next question, again, regarding Terrio, did the Crown argue that the lesser included offense of simple assault would be included in the Terrio case? Story about the co-accused.
It was a brief mention in a single sentence at the end of lengthy submissions, but in any event, yes, it will be a ground of appeal. It is a very interesting legal issue, whether you can parse a factual situation into separate transactions like that.
Okay. Question number 20. Any idea or insider knowledge on whether the co-accused Terrio brothers' sentencing will be broadcasted on YouTube?
It will have to be if courts aren't sitting. But for example, I understand courts are going to resume sitting in August, and I'd be surprised if the sentencing is before then. So I suspect it will take place in an actual courtroom.
Yeah, and this is actually, I think, an interesting question. His Honor made a bunch of negative credibility findings about the complainant's evidence. What are the limits that this might have on the complainant's victim impact statements? As the questioner says, he didn't understand the judge to accept Miller's version of events, that he was not car hopping, that he was randomly targeted. So what, if any, hay can be made in the context of the victim impact statement about the negative credibility findings?
Well, I think the victim impact has actually already been in evidence on the record in terms of the injuries in that. So I don't think it makes a practical difference. But the point is that the issue is that sentencing will be limited to a simple assault with no consequential injuries proved, but with the use of a weapon, namely a pipe, an aluminum pipe used. That's the basis on which sentencing will take place.
And just as a follow-up to this question, it just seems difficult to parse that into challenging a victim impact statement credibility. So just looking at any other case, just as a follow-up question, do you see any possibility that you could ever say, well, the witness, even though there was a conviction, was found incredible on these points, so how can we trust all of their emotional difficulties that they have in their victim impact statement?
Perfectly legitimate argument. Absolutely. A victim impact statement has to be assessed for credibility. And if the trial has made decisions about the victim's credibility, then it applies to the victim impact statement.
Okay. And question number 21, again, another Terrio question. In this case, the lawyer wants to say, am I right that the issue in the Terrio case is one of causation of the eye injury? His Honor was not convinced beyond a reasonable doubt that the assault caused the eye injury, the assault that the finding of guilt was made on. Yet His Honor stated that the using of a weapon was an aggravating factor to that assault. But His Honor had doubt about whether the injury was caused prior to the assault he made the finding of guilt on.
Yes. Yeah, the questioner has parsed it correctly. The tragic injury was caused during physicalities that were justified by self-defense, or at least were not proved not justified by self-defense. So the subsequent assault resulting in the conviction, although it involved the use of the pipe, there were no injuries proved to result from that particular assaultive behavior.
Okay. So the next question again regarding the co-accused in the Terrio case, His Honor did not make a finding about causation of the injuries. Do you have an educated guess on the range of sentence? I didn't.
No, I haven't. I not researched that. I wouldn't even make an educated guess. It's.
I imagine there'd be angry emails from Michael Lacey coming if you did. Question 23. I have an impaired over 80 case with an offense date of May 12th, 2018. The breath tech is no longer able to testify or available. An application has been made pursuant to the old regime 2586 and 2587 and the alternative 320.32 sub 4, which is under the new regime. My question for you is, what will this hearing look like? What evidence, if any, do I need to call? I realize it's my onus, but what is the judge going to want to hear from me specifically as to why the breath tech should be there to be cross-examined?
But that's exactly the issue. The application under 320.32 sub 4, the application, you have to set out the proposed cross-examination and its likely relevance. So once you do that, I'm not sure you're going to need any evidence, but yes, absolutely, you're going to have to explain to the judge why you should cross-examine the technician. Now, hopefully, that will be because you found some issue with the paperwork, or the client has provided some information like, I noticed the room was really cold when I took the test, so that might affect the temperature. The machine has to be at a certain temperature, or the client might say, I belched, I burped just before I took the test, or they never watched me for 15 minutes, whatever. But yeah, you have to set out some reason for cross-examining a technician, and that will provide enough of an evidentiary foundation to get leave or not.
Okay, question number 24. Will recordings of the previous sessions be available later? My understanding is all of these are recorded, and the CLA is planning on releasing them closer to the fall when people are looking to fulfill all their CPD obligations. Question 25. What are the pillars of a successful practice in your opinion?
I'm sorry, I don't have any magic answers. Adam will verify. It's simply hard work, constant learning. That pays off a little bit. You do some case and you do it as well as the case allows, and people watch you, and the clerks say, hey, that was a great job, and they tell their friends, etc. You get a modicum of success that incentivizes even more hard work, more learning, and soon, hopefully, you become a victim of a not so vicious circle, producing a happy professional life. You need devotion to what you're doing, devotion to the profession, but it's simply hard work and sticking at it and doing your best job and being a pleasant person, and people will say nice things about you, and you build a reputation, and once in a while you get a great client, you do a great job, you work hard, etc., get a noticeable result, you wake up 40 years later, and all of a sudden you're successful.
Question number 26. My client was charged with assault causing bodily harm. Can she use the defense of consent if she did not intend the bodily harm to be inflicted?
Yeah, yes. Consent is vitiated if bodily harm is intended, not just caused.
Okay. And engaging in the fight with the complainant who goaded my client on and followed her when my client tried to walk away. My client came into contact with the complainant's face. Okay, so yeah, that's it.
Yeah. If your client intended to cause bodily harm, that vitiates consent.
Okay, so here's a personal question. What's your preference, Westlaw or Quick Law? Or is Canley going to take them over?
Yeah, I have a professional relationship with Quick Law for almost 30 years, so I find it easier to use. I'm used to it. I do find it more complete. So yeah, I have to prefer that, but Westlaw is a great system too. They have great people and lots of useful information. Canley is incomplete, but it is good. The most important thing I'd remind you is courts have rules about citing cases. So especially appellate cases, but even all cases, courts prefer the neutral court site first. Okay, and then you can use Canley, and then you can use one of the professional services such as Quick Law or Westlaw. But I think you'll find most court rules now say use the neutral court site first.
Okay, so the next question I have, it's just someone's labeled 228s. So the next question, 28, is male client with limited English charged with sexual assault, petting a woman in a train station. There's lots of video, but there's no audio. The defense is mistaken belief and consent. The sought after consent are her actions, giggling, smiling, and staying put while he touches her. I guess these are the inferences supporting consent. To answer the question, did the accused believe he had obtained consent, I propose an expert in affection transfer theory. This expert is to say that people express affection in different ways. The way the complainant behaved, the expert will say, could be interpreted as consent by an accused. Alternative, a cultural expert from the client's native country on affection norms. Are there any problems with these two approaches?
Well, first of all, there's no audio, and unfortunately, I can't suggest a lip reader. Affection transfer theory is not something I'm familiar with. So I looked it up, and apparently it's actually affection exchange theory, and it was introduced in 2001 by a communication scholar named Corey Floyd. So it sounds very interesting, but I don't understand why you need experts. If in fact your client's position is I touched her and she was giggling, smiling and did not move away, remember, that's the defense of mistaken belief. And the defense of mistaken belief can be based on anything the complainant said or did at the time. So that's your defense. If the judge accepts there's at least a reasonable doubt that she giggled, smiled, and stayed put, it's got to be a not guilty. Now, I'm presuming she will testify did not consent, so you don't have actual consent. Your defense is mistaken belief, which is based on any communicative words or actions by the complainant. You seem to have them. I don't think you need an expert to explain them to a judge. If you touch somebody's behind and they look at you and giggle and smile and don't move away, that's reasonable. That's more than reasonable evidence of apparent consent leading to your client's mistaken belief. So I don't think you need experts. It's not as if she behaved in a way that isn't commonly understood as affection in our society. It's not as if there was some strange reaction that needs an expert to interpret. So,
not to be difficult, but doesn't the consent need to be communicated before the interaction? So in this case, I'm not clear that it's showing that there's any communication prior to the touching.
It was simultaneous.
Okay. Question 28. Justice Nordheimer dissented in Gotra. I think you mentioned this before about going to the Supreme Court.
Yes.
And His Honor agrees with the principles in Ahmed that the police were prohibited from engaging in random virtue testing because of praising the weakness of human nature. What are your thoughts on this case other than you're going to take it to the Supreme Court and win?
Yeah, I think people forget that's what entrapment is all about. You don't want the police going out randomly testing whether we would commit a crime or not if given the opportunity. That's not the police function. The police function is to catch criminals, not to make criminals. So I think Justice Nordheimer's decision is dead on, and yes, we are taking the matter to the Supreme Court of Canada. See what happens.
So question 29. When you're cross-examining a child in a child-friendly room, do you prefer to be present in the room with the child or to be in the courtroom?
I never got that question.
Oh, sorry.
The new question. So I've actually never had that situation. I'm not sure I have an answer because I've never been in that situation. I just think the important thing with children is how you communicate with them. I'm not sure it matters whether they're in the same room or not.
Yeah, I've done it before, not being in the same room, and it's been fine. It's not the end of the world. And in some ways, I think if you're in the room with the child and the judge isn't in the room, it might look like you're influencing them in some way. So I think it's a matter of preference. You should be able to outsmart a child whether you're in the room or out of the room. So that's the end of our session today. Sorry we were 5 minutes late. I put up a poll. If everyone could just answer the poll before you leave, just so we have a sense if we're going to do this again for a session 5. And we'd both like to thank all the people who send in their questions because that's what makes this possible. And Mr. Gold is committed to doing this as long as there is interest. I'm going to keep dragging him here on a Monday at 4 p.m.
My pleasure.
All right. Thank you very much, everyone. So we'll just leave the session up until everyone answers the poll, and then we'll decide.
Have a good week.
All right. Thank you, everyone.